Good afternoon, everybody. Happy GDPR Day today. That's what my LinkedIn's been saying all the way through today. Happy GDPR, happy birthday GDPR. So here we are. I'm the DPO for the University of Warwick. It's a well-known university across the world. It's top 10 in England, and I think it's also in the top 50 in the world. I'm sure it's not number 50. It's got a higher ranking than that. As the University of Warwick, we're really, really huge, and we've got a lot of businesses. So we've got a gym, we've got an art centre, we've got a cinema, we've got a conference centre, we've got hotels, we've got subsidiaries across the world, we've got partnerships across the world. So we actually do a lot. We do a lot of transfers of data across the world as well. So we're really, really involved in virtually everything to do with data protection. Of course, research and providing education as well as our public tasks. Okay, so the implications for us in the university sector for GDPR. The first and foremost thing to remember is that GDPR is group liability. And because we've got businesses across the world, and because we've got a lot of subsidiaries, this is foremost on our minds. We have to have all our subsidiaries aligned to our data protection policies and practices across the university. So we actually have one overarching data protection policy. We have one overarching staff privacy notice, and we have one overarching student privacy notice. It's on our website. It went live on Wednesday. But we also have then local privacy notices and local data protection policies depending on what business we've got. So the gym will have their own data protection policy, which is tied into our overarching data protection policy. We're mindful of the fact another implication for us is that the GDPR has broader territorial reach. The burden of accountability is much higher for us. We need to actively demonstrate compliance. So this would mean things like DPIAs and having auditable consents in place. So when the regulator comes knocking, when a data subject has complained that, the university's written to me for direct marketing and I haven't provided consent, the regulator will ask us, show us your consent. And I've heard that from the horse's mouth, which is the regulator. We have to bear in mind contractual liabilities. We have to bear in mind something for indemnities. It's really important that we get our indemnities spot on in any contractual paperwork. And also we have to bear in mind the claims for compensation and legal claims will be rising. We're already seeing that. Data subjects are really aware of their rights now in the UK because of all the press that has picked up on GDPR. Okay, then with the alignment with the GDPR, my next topic is data protection by design and default under the requirements of Article 25. All roads lead back to Article 5, which is the accountability article. So we have to be accountable for everything we do. And Anthony touched on earlier on the processor's responsibilities, but still it's the data controller that is really holding the whole raft of responsibilities under the legislation. You need to have, as a university, DPIAs embedded in your key processes. So this would be in your procurement process, in your ethics approval, in your partnerships with other universities, and when you are partnering with them, what do you need to look at? Not just your QAAs, you also need to be looking at your partnership agreements to include data protection provisions, who's got responsibility for what. Also, when you're doing your data protection impact assessments, don't forget to look at the screening questions before you actually do the DPIA. So you need to actually have something documented. Yes, I did consider whether I need to do a DPIA or not, and then sort of take it from there, but make sure it's documented. Ensure that you're relying on the appropriate lawful basis for processing. So I've got at the end of my slide here, end of that sentence saying C equals P, which means your consent must equal your purpose. So you can get consent, but if it doesn't equal your purpose, then that consent is not fit for purpose. So bear that in mind. You need to have your Article 30 records of processing in place. That is going to be your blueprint, your data inventory. You need to know where your data is, what you do, how you hold it, and everything that's required for records for processing. It's quite important. And that's what I've been concentrating my time on since my time at Warwick in the last few months. I only started Warwick in November 2017. I was the DPO for Coventry University before that. And records of processing is a huge task for universities because we've got departments that process data perhaps not in a consistent manner with the centre. So you might have, say, an HR procedure where you're recruiting somebody, and the centre will, that is the professional services, will issue guidance on how to do it, but each of your departments might have different procedures on how they recruit. So bear that in mind. Ensure your agreements meet the requirements of Articles 28, 32 and 35. Adhere to data subject rights and principles by looking at the ICO's 12 steps. So our regulators issued a 12-step guidance. When I first saw it, I wasn't that impressed by it. But now I use it to structure myself and structure my work as a data protection officer. And it is a really useful structured approach to take if you follow the 12 steps. Look at your main data capture points. So this would be for a university, most universities, enrollment, research and employment, and make sure you have your privacy notices that allow you to process that data. Aim to have single repositories with role-based restricted access to avoid duplication, BCDR, ease of adherence to data subject rights. So if you've got student records, make sure they go into the central student record and they're not sitting outside the central student record system. Most of the universities in England use a system called SETS, and we all work towards that. So we need to have documented policies and procedures for data protection and information security because they go hand in hand. I often say information security and data protection are two sides of the same coin. Have robust systems to store your data. Ensure you've got your privacy notices. Enforce mandatory training for all your staff, and this is a statutory task that your DPO needs to sort of complete. So that your DPO will need to ensure there's a system in place that ensures the training of all staff and how ensures also to satisfy the regulator on how that training is implemented and governed. Make sure you've got a data classification policy. We've got one. It's on our website. Ensure you've got a records management policy, a record retention policy, and make sure you embed privacy by design and default across all your policies and procedures, and make sure you've got implementation and enforcement of those policies as well. If you've just got a policy that is just written like a policy and there's no enforcement sanctions in there for your staff, there's no point having it. The IC always says to us, so you say you have a training policy. If your staff are not training, how do you enforce that training? If they're not training, what sanctions are in place to make sure that staff are training? So you need to have that in your policy. Breach response plan should be documented, because there should be a duty for staff to report, and like Anthony said earlier on, you've only 72 hours to respond, and it's not a lot of time if you think about it. There's a lot of contracts that we look at, a lot of agreements, a lot of arrangements that take place. Sometimes they're called memorandums of understanding, sometimes they're called memorandums of agreement. Whatever they're called, there is some agreements in place. A lot of those are not aligned to data protection legislation. So it's very difficult now to look at all these vast number of agreements and think, where should I start? So what I thought was perhaps we should have a formulaic approach to looking at those agreements that we have. So the first, in order to vary them and align them to the GDPR requirements. So if an agreement processes biometric data, you need to be looking at that first. Then look at the fact if it's got special category data. Does the arrangement process children's data? Is there international transfers in that arrangement? Do you undertake profiling? Look at the volume of data processed, look at the value of the contracts, and look at contractual indemnities. This should give you a guideline on which contract to pick first and carry on from there. I was speaking to my equivalent at another university, and they said they've got about 4,000 contracts to go through. Imagine the amount of work that is. You know, you could throw 50 people at it and you still wouldn't be compliant in 2 years. So the next slide is the task of the data compliance team. This is what my team does under my instructions, under my role as DPO. So the first and foremost task of the data protection officer is to ensure that the university is compliant and to assess compliance. So how do you do this? You can't do it on your own. You need to do it with a team. So ensure there's a governance structure to support accountability requirements, e.g., for example, like I mentioned earlier on, the procurement process. I've called it the DP bill, but really now it's an act because it was only passed on Wednesday for us, so it's quite recent. We need to respond to the requirements of the Data Protection Act 2018, as well as the requirements of the the GDPR. We need to respond to PECA, which will become the e-privacy regulations. As DPO, there is a continued assessment. I use the ICO's tool on continued self-assessment to see where we are, which helps me to get along or sort of review the GDPR gap analysis for the organisation. Contracts I've already touched on. Anthony's touched on cross-border data transfers. But we do need to review the legal mechanisms. I find as a university and across the university sector, we've not been using the EU model clauses, although they've been around for a very, very long time. We need to review our systems. That's another task for the DPO to push through to ITS to say, do we have GDPR compliant systems in place? The DPO has to ensure that the data subject's rights are met. It's quite important. Otherwise, you're looking at 4% fines for any breach of any of the data subject rights. If you look down I think it's Article 82, I can't remember now. Data breach notification is also another key element of the DPO's role. And carrying out departmental audits, carrying out partner audits, carrying out subsidiary audits. This is another function of the data protection officer. The data protection officer is stuck sometimes because the data protection officer's role is to work with the organisation to meet the requirements of the GDPR, but also work with the regulator at the same time and make sure all the data subjects' rights are met. And it can be quite a difficult task, actually, because you're stuck sometimes between a rock and a hard place, and you have to be independent. You have to have the authority and the ability to be independent. The Act certainly gives you, the regulation certainly gives you that independence, and you need to use it and you need to embrace it. And it is a protected status, so you should be able to exercise that independence. The data transfers outside the EEA is quite an important topic for universities because we really do collaborate working across the world, whether it's for providing education, whether it's for providing student exchange agreements, or whether it's for research purposes. And we need to bottom this out and get it right. When we are looking at data transfers outside the EEA, we forget about local law. We only concentrate on what law we're subjected to. And what about local law? What about if you're operating in China, if you're operating in Singapore, if you're operating in Malaysia, India? Some of these countries have sanctions which carry out imprisonment. You really do need to think about data protection in those countries and look at your own law, which is the GDPR, and then look at the law in the partnering country. In Singapore, for example, if you operate in Singapore and you've got a subsidiary or office in Singapore, you need to go and register as a data protection officer in Singapore. In China, you need to have a yearly information security audit. Who's going to do that? Have you looked at that? Those sorts of things are important for you to bear in mind. When you've got representative staff in offices abroad, are you confident about the devices that they use? Are you confident about your security infrastructure in those offices? If your office is using an ITS infrastructure that is producing latency to connect to the main server, say in the UK, you already know you've got an issue. If you've got latency issues, local staff will download information locally and store it on their laptops locally. What happens then to the security principle? What if the device is unencrypted? You've got to really bottom this out, and you need to go and review with ITS the systems that are in place. Effectively balancing the need to meet GDPR expectations whilst continuing with institutional targets, it's a very, very difficult task. Your senior management team or your university executive board need to adequately resource the data protection function. If they don't put money in the function, it's not going to work. It's not going to be operationally safe for the organization. The data protection officer needs to have the ability to act independently, and they need to be provided with a budget. The legislation actually says to provide the data protection officer with adequate resources, officers, and staff. You can only do this task if you've got a multidisciplinary team. So you need a mix of information security officers, records managers, and lawyers to carry out this task. Legacy arrangements, which I touched on earlier on, there's a huge deluge of live contracts which require technical resource. Is your organization going to invest in that or not, is a question to ask. Do you have a risk register? Have you registered on the risk register all your risks? You need to, so the organization's aware and the organization takes responsibility of those risks. If you don't do that as a DPO, you're failing in one of your tasks as a DPO. Also, what's really important is that you have a data strategy or a roadmap. You need to document this because the ICO will want to see it. Our regulator will be asking for that if there's a data breach. Okay, so what do you need to do? Just some tips for now. Look at your data handling practices and procedures. Document them. If they're not documented and they're just in your head, what's the point of having them? How will you mitigate any circumstances that are adverse to you in relation to a data breach situation if you haven't got documented practices and procedures? Look at your mass emailing policy. Look at your email circulations. Do you need to copy everybody in an email chain? It's really important that you look at this. Look at your access controls. When people are working on shared drives, do they need to access everything on those shared drives? If you don't have that in place, you could be opening yourself up to risk. Have a clear desk policy. Sometimes I walk around my office, my office when I stay in the university. Sometimes I walk around in other offices when I go to other organizations or meetings. I see so many desks littered with paperwork. Why? Why is not such a basic policy in place? It's a low-hanging fruit. Somebody should be able to look at this and say, right, we're going to do something about this. Confidential waste. Use confidential waste. It's there for a purpose. There's no point having confidential waste sacks at the end of your desks if you're not going to use them. And make sure that the confidential waste is collected and not just left there for anybody to come and put their hands in and take out and say, oh, this will make interesting bedtime reading. Secure deletions, really important. I can't labour this enough. If you're in doubt and you don't trust the confidential waste, delete it using a shredder. Make sure if you are ending your relationship with your laptop for 5 years, make sure it's data cleansed. It's important because people have been caught out on this. And one of the things I'm still finding after so many years of practicing in this area is organizations are still not using encrypted devices. Again, it's a low-hanging fruit. You know, a lot of breaches come about because of non-encrypted devices. So just a quick review for yourselves. What data is it that you hold? Why are you holding it? Does it go to the data purpose principle? Where did it come from? Did the data subject give it to you, or did you buy it off a list? Who are you sharing the data with? Review your data sharing terms and agreements with third parties, including your processors. Review details of transfers to third parties. Check whether you're legally allowed to do this. Check what your lawful basis for processing is. Check your retentions. We always forget about retention. And check security. I've got a data protection working group with the ICO, who's our regulator, and JISC, and some other HE, I'm nearly finished, and some HE organisations like HESA, like the MRC, which is our Medical Research Council, HESCI. It's really important for us as a sector to mobilise ourselves. So if you work with other people, you can share practices, learn from them, and try and see if you can get in touch with your regulator and see if they're happy to sit or send a representative to a working group that you might want to establish. You can all work then from joint templates on privacy notices, on your security measures, consents. I'm quite happy to share mine. If anybody wants to contact me, my details are available on the university website. If you want templates on contracts, on privacy notices, etc., just get in touch. Okay, anybody got any questions? No? Okay.
One question, yes? You.
It's me. How do you treat fingerprint authentication on laptops, on other devices?
We're not bound to have fingerprint or biometric data devices for our employees. So if an employee wants one of those devices, they actually have to sign up to terms of service, and we would provide those under terms and conditions if they want them. That's how we deal with it in my organisation. Does that answer your question?
That's some sort of waiving the responsibility of this biometric data processing.
But do you need biometric data to provide your employee with a device? Do you need their biometric data? You can still do the job without it.
When you enable this function, you actually are storing this reading in some sort of directory where you attach assign the fingerprint, the actual fingerprint to a specific user. So you are in fact processing biometric data. That's the whole process, and that's considering by Gdpr regular as a sensitive data.
I agree with that. So that's why I'm saying, one of the principles under GDPR is data minimization. What that says is if you don't need that data, don't collect it. We had a situation at the university where one of our businesses, our subsidiary businesses, wanted to collect people's fingerprints to access the building, and we had to put a stop to it. So it really depends on your university, on your data protection officer.
You stopped using fingerprint access control?
Yeah.
So that was easier than to create this compliance procedure.
But why do you need the data? Why would
convenience and security?
But convenience is not the answer for somebody to implement compliance. How does that go to the data minimization principle?
Why do I need minimization if I need convenience in daily operations?
But if you need convenience in daily operations, you're saying that's your legitimate interest. Legitimate interest doesn't apply to special category data, and that's biometric data.
Okay, that's an interesting idea.